But we now know trauma affects everybody differently. Not showing overt or public signs of grief doesn't mean someone doesn't feel the same loss as another person. It simply means, Mr. Assistant President, that we all grieve differently. Kathleen Folbigg was grieving for the loss of her 4 babies. I respect that the Attorney-General has decided to wait. May I please have just another 30 seconds, Mr. Assistant
Leave
President?
granted?
Yep, I respect that the Attorney-General has decided to wait for Tom Bathurst KC's report. But I do urge the Attorney-General to act immediately he receives the report and pardons Kathleen Folbigg, as every day in prison is a day too long. Mr. President, thank you for the extension in time, and I also just wanted to give a very big shout out to a very amazing person in Bridget Glanville here today. Her history doesn't need anything exaggerated from me, but her advocacy in this case as well, pro bono, should be commended. Thank you very much.
Further speakers? The Honourable Stephen Lawrence.
President, I rise to speak in support of the amendment and the government position. I can hardly underestimate the significance of this issue. In my opinion, it's the most significant development in the criminal justice system in New South Wales in living memory. The horror of what we are dealing with here can also scarcely be understated. The horror of the death of 4 children, the horror of the prospect of the murder or manslaughter of children, the prospect of the death of 4 children by natural causes, and perhaps most importantly, in light of the concessions that have been made at the inquiry, the prospect of a person losing 4 children and then being wrongly convicted of the intentional homicides of those children. It's perhaps those horrors that make this case quite difficult to engage with on a human level, but engage with it needs to be done. The ancient powers that exist now in part in statute to parole or pardon are aspects of the prerogative of mercy. They are important powers, and the Chamberlain case shows how crucial it is that the repository of those powers always stands ready to exercise them. And it's relevant to recall that Lindy Chamberlain, I think, was released on licence or parole prior to the Second Royal Commission and prior to the ultimate pardoning and then acquittal. It's relevant to note too that Tom Bathurst is not sitting in this inquiry as a member of the judicial arm of government. He's sitting as a member of the administrative arm. It's relevant to note that Tom Bathurst himself in the inquiry had cause to mention that these powers were independent of the powers that he exercises. It's important to reflect, I think, on the role of the DPP and counsel assisting. I've played the role of counsel assisting in a number of coronial inquiries. The person playing that special role confers with the inquirer on a regular basis. They plan lines of questioning and they help to write the judgment. Of course, the DPP plays the role of contradictor in these proceedings in a sense, but they are the prosecutor in an adversarial system of criminal justice. The significance of their concession in that inquiry can hardly be understated. They would be the contradictor in any future appeal proceedings. So what can we ask of the Attorney-General? Well, we certainly can't put undue pressure on him or prejudge those decisions that are his to make. All I would suggest we can ask of the Attorney-General is that he is ready to exercise his powers at any time, that he doesn't delegate the exercise of his powers constructively to any other person, and that he stands ready as the repository of those powers to give mercy if mercy is warranted upon engagement with the issues, the facts and the evidence.
Further speakers? The Honourable Natalie Wood.
Thank you, Mr Assistant President. I rise on behalf of the opposition. Can I thank Ms Higginson for bringing the motion before the House, and I know she comes with great intent in doing so and diligently does so, and can I acknowledge those supporters of Kathleen Folbigg in this chamber and their relentless, tireless devotion to their friend. Can I also just acknowledge the loss of these precious children? I think the loss of children in any circumstance is devastating, and in this, I know that we all come to this place with genuine intent to see the right thing done. and I mourn for them and for their mother and for their family. Can I indicate that I am aware of the government's proposed amendments to the motion, and that at the outset I can indicate we will be supportive of those amendments, and should they be successful, of the amended motion. I just want to put on the record a couple of things, given that this came to us as the previous government and the Attorney-General, the now Leader of the Opposition, and note that the Opposition believes in the rule of law and the right to due process within the criminal justice system here in New South Wales and across Australia. It's a foundation of our democracy. But as an inquiry is underway, I'm hesitant to comment directly on the specific components of it. And as the Honourable Bronnie Teller says, there's too many lawyers in this place as it is, so I'll leave it to them. I merely hold a practising certificate. We are aware, just a fallback, we are aware as an opposition of the media coverage surrounding the inquiry, and note that the inquiry instigated by the previous, by us in the previous government, was something we believe should be seen through. When in May 2022, the now Leader of the Opposition as Attorney-General then recommended that the Governor appoint retired Chief Justice the Honourable Thomas Bathurst ACKC to conduct a second inquiry into Ms Folbigg's conviction, we did so in the belief of that process coming to a view, and that a transparent, public and fair process can provide a just resolution. I'm going to ask the Chamber for its indulgence with an extension of time just to get some of these matters on the record, if I may, Mr Assistant President. 2 minutes, if I may. As the Attorney-General indicated at the time, Ms Folbigg's legal representatives contend that the new scientific evidence is compelling, and I am advised that the 2021 petition raised new scientific material published since the first inquiry into the convictions. Sorry, Mr Assistant President, I seek leave for a 3-minute extension. I will be less though.
I can give you 2.5 minutes.
Thank you.
Is leave granted? Being no
Thank you.
opposition, leave is granted.
Thank you. We note that the new material concerns developments in the scientific understanding, and forgive my explanation, of the CALM2 genetic variant found in Ms Folbigg and her 2 daughters, Sarah and Laura. The new scientific material predicts that the CALM2 genetic variant in question causes disease, and that carriers of it are prone to cardiac arrhythmias which can cause cardiac arrest during sleep. The new scientific material and the implications it has for Ms Folbigg's case are complex, and they need to be carefully and thoroughly scrutinised by appropriately qualified experts and investigated in the context of her case. But we know that she has been unsuccessful in numerous public proceedings to date, and there is a need for fairness and there is a need for transparency in that process. Against that backdrop, the then Attorney-General explained that it wouldn't be appropriate for the Governor to grant a pardon, or, for example, for the Governor or he as the Attorney-General to receive private briefings from experts with a view to considering granting a pardon without that evidence being properly scrutinised independently and in a public forum. But at the conclusion of Mr Bathurst's inquiry, I note a report will be prepared, and the outcome of that will be a matter for the Judicial Officer, in this case Mr Bathurst. The Crimes Appeal and Review Act sets out the actions that may be taken on completion of an inquiry, and they involve a review of conviction under the Crimes Appeal and Review Act if the Judicial Officer who conducts the inquiry finds there to be no reasonable doubt as to the convicted person's guilt. Then a report will be provided to the Governor, and the Governor may then dispose of the matter by taking no further action. If the Judicial Officer who conducts the inquiry finds there is reasonable doubt as to the convicted person's guilt, then the Judicial Officer can refer the matter to the Court of Criminal Appeal, and that court, in considering a report received by it from the inquiry, has the power to quash that conviction and grant the convicted person an acquittal. In either case, the Governor can grant a convicted person a free pardon. A free pardon has the effect of relieving a convicted person of the consequences of their conviction, so they wouldn't be required to reserve any remaining time on their sentence. However, that doesn't mean the conviction is quashed. If there has been an inquiry, then a convicted person who has been granted a free pardon can apply to the Court of Criminal Appeal for it to be quashed. Nonetheless, guilt, innocence and the matter of custodial sentences are extremely serious matters, and we support the view of the new government to look at this very closely, to consider whether there is something they can do more urgently than that process, given appropriate advice, and in the circumstances where they are being called on to act appropriately and as soon as practicable. If those amendments are successful, we will absolutely be supporting those in this House, and I support the amended motion if it's to be the case.
The time for this debate has expired. Ms Sue Higginson in reply.
I thank the Honourable Member Robert Borzak in particular for his contribution, the Honourable Daniel Mookie, the Honourable Rod Roberts, the Honourable Emma Hurst in particular, the Honourable Bronnie Taylor in particular, and the Honourable Stephen Lawrence for that incredible insight into the role of a counsel assisting an inquiry and the role of an inquiry, and I thank the Honourable Natalie Ward for contributions. It does astound me, the conflation of what's in fact happening here. It's not a judicial inquiry that's been undertaken, it's an administrative function. It's completely a separate process to the plea and the petition and what Kathleen Folbigg's legal team has been asking for. They're asking for a pardon and for release immediately. The Attorney-General right now has the power. He is the Attorney-General, he is the leading law officer of this state. He is the only person right now that stands in between justice and the gravest injustice that we know when we're talking about a rule of law system, a democracy, a functioning system. We are talking about the wrongful incarceration of a person, a 55-year-old woman who has spent 20 years in prison and is now going to spend some more time in prison. The Attorney-General has the power right now to actually look at the volumes of evidence. It's very hard when you've actually read every single word and you've gone through every volume and you've looked at every transcript to then go to sleep at night knowing that she's still there and you're out here. It's very, very difficult. I've read every single word. I'm a lawyer of practice, and I can tell every single person in this House that you should support this motion unamended. The fact that it will be amended and does provide some serious leverage is something that we will accept and we will work with. We will not stop our pleas directly to the Attorney-General to do the right thing. This state deserves an Attorney-General who is willing to engage in the law, in the systems before him or her, and do the right thing by justice. If you don't have a justice bone in your body, then you should not be sitting as the Attorney-General. That is the role of the first legal officer of this state. At the moment, a woman is in prison, and on the face of all of the expertise in this state, in this country, she is there in spite of the very basic fundamental legal premise. There is reasonable doubt as to her guilt and her conviction. We are waiting for one more man to put pen to paper to say the very things that have already been said. And the Attorney-General's power does not rest on that. It is not contingent on that. Please support the motion unamended.
Ms Sue Higginson has moved private members' business number 57, to which Mr Mookie has moved an amendment. I propose to put Mr Mookie's amendment first. All those in favour, please say aye. Aye. Those against say no. No. I think the ayes have it. The noes have it. No division required. Ring the bells. Order, lock the doors. The question is that the amendment proposed by Mr Mookie be agreed to. The ayes will pass to the right of the chair, the noes to the left. I appoint as tellers for the ayes the government whip and the opposition whip, and tellers for the noes Ms Kate Fairman and Mr Robert Borzak. Just an assistant. Order there being 31 ayes and 8 noes, the question is resolved in the affirmative. Unlock the doors. I now propose to put the original motion as amended. The question is that the motion be agreed to. All those in favour, please say aye. Those against say no. I think the ayes have it. The ayes have it. Can members please take their seats? Clerk will read the order of the day.
Item 4, private members' business number 52 in the name of Mr Banasiak relating to the Property Services Council Bill.
The Honourable Mark Banasiak.
That leave be given to bringing a bill for an act to constitute and confer functions on the Property Services Council and for related purposes. The Property Services Council